The International Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please, the matter.
Good morning, Mr. President, Your Honors. Situation in the Republic of Côte d'Ivoire. In the case of the prosecutor versus Laurent Gbagbo and Charles Blé Goudé. Case reference ICC 0211-0115. And for the record, we are in open session.
Thank you very much, officer. Now, we will take appearances, beginning with counsel for the prosecution.
Good morning, Your Honours. Appearing today for the prosecution, we have Mr. Reinhold Galmetzer, Appeals Counsel, Ms. Priya Narayan, Appeals Counsel, Mr. Eric McDonald, Senior Trial Attorney, our case manager, Ms. Neera Mandavia, and I'm Helen Brady. I'm the Senior Appeals Counsel. Thank you.
Thank you. And next appearances from counsel for Mr. Gbagbo.
Mr. Altit. Good morning, Mr. President, Your Honors. The defense team is made up of Jennifer Nauri, sitting beside Mr. Gbagbo. Behind me, Professor Jacobs, Angèle Gengorge, Fiona Ganteret, and as for myself, I am Emmanuel Altit, lead counsel representing Mr. Laurent Gbagbo.
Merci. And next counsel for Mr. Blé Goudé.
Good morning, Honours. Mr. Blé Goudé is today represented by co-counsel Mr. Claver Nindri, my left side. In the second row, Mr. President, legal assistant Mr. Siri Zuku, the bar Brussels, Madame Antonia Dijk, legal assistant Sarah Pedroso, and on the second row you find one of our new assistants, Ms. Despuina, and I have to pronounce it very correctly, I was told, Elefirio. I hope I pronounced it correctly. Thank you, Mr.
Can
President.
you spell it, please, for the record, so that
Yes.
the court record can get it correct?
Yes. We can also send the names later to you, to save time.
Fair enough, fair enough.
I'm lead counsel for Mr. Blé Goudé, Alexander Knoops. Thank you.
Thank you. And the record will reflect that both Mr. Gbagbo and Mr. Blé Goudé are in the courtroom. Next, we take appearances from the Office of Public Counsel for Victims.
Good morning, Mr. President, Your Honors. Victims participating in this proceeding are represented by counsel from the Office of Public Counsel for Victims. In attendance this morning, next to me, Ms. Peña Ana, case manager, and I am Paulina Masida, principal counsel.
Thank you very much. And lastly, we take appearances from counsel for the government of Côte d'Ivoire.
Bonjour, Monsieur le Président.
Counsel, good morning, Mr. President, Your Honors. The government of Côte d'Ivoire is represented at this hearing by Mr. Mignot, Mr. Blat, a member of the Paris Bar, and myself, also a member of the Paris Bar, Mamadou Kone, and Abdoulaye Meite, who is a member of the Abidjan Bar. I thank you, Mr. President.
Thank you very much. We also take appearances from the Office of the Registrar.
Mr. Dubuisson, thank you, Mr. President. Your Honors, with me representing the registry, Jamila Joubris and Romina Morello, who is an advisor dealing with external relations and cooperation. As for myself, I am Marc Dubisson, the director of the Division of Judicial Services, representing the registrar, Mr. Peter Lewis.
Thank you very much. We've taken appearances from everyone. Thank you. The Appeals Chamber is convened to hear oral submissions in the application of Mr. Gbagbo, dated the 7th of October 2019, requesting the Appeals Chamber to reconsider an earlier decision, which hereafter I will refer to as request for reconsideration. I will now summarize the background to the proceedings of today. By a majority judgment announced on the 15th of January 2019, the trial chamber acquitted Mr. Gbagbo and Mr. Blé Goudé of all charges against them in the present case. Judge Herrera Cabuchia dissented. The next day, on the 16th of January 2019, the prosecutor made an application to the trial chamber requesting that Mr. Gbagbo and Mr. Blé Goudé should not enjoy the benefit of absolute freedom that usually accompanies an acquittal. Instead, they should only be released subject to conditions to a state willing to accept them on its territory with such conditions. But in the event that no such state may be found, the prosecutor requested that Mr. Gbagbo and Mr. Blé Goudé should be kept in detention pending the outcome of the appeal that the prosecutor intended to file against the acquittal. The trial chamber, by majority, rejected that application. Again, Judge Herrera Cabuchia dissented. On the 23rd of January 2019, the prosecutor appealed against the trial chamber's decision rejecting her request for conditional release of Mr. Gbagbo and Mr. Blé Goudé. On the 1st of February 2019, the appeals chamber had oral submissions from the parties and participants in that appeal. On the same day, the appeals chamber issued its decision on the prosecutor's appeal on that matter. In the decision, the trial chamber did the following, amongst other things. A, the appeals chamber amended the trial chamber's decision and imposed conditions on Mr. Gbagbo and Mr. Blé Goudé upon their release to a state willing to accept them on its territory and willing and able to enforce such conditions. B, the appeals chamber directed the registrar to identify and enter into arrangements with a state willing to accept Mr. Gbagbo and Mr. Blé Goudé, or both of them, on their territory and enforce the conditions. And C, the appeals chamber indicated that it may vary the conditions of release in the future on the motion of the appeals chamber itself or on the motion of a party or participant. On the 7th of October 2019, Mr. Gbagbo filed his request for reconsideration of the appeals chamber's decision of the the 1st of February 2019. Responses to Mr. Gbagbo's request for reconsideration were received on the 16th and 17th of October 2019. On the 20th of December 2019, the appeals chamber scheduled a hearing in this matter to be held on the 6th and potentially also the 7th of February 2020. We leave of the Appeals Chamber on the 22nd of January 2020, the government of Côte d'Ivoire filed observations in relation to Mr. Gbagbo's request for reconsideration. On the 30th of January 2020, the Appeals Chamber issued a decision on the conduct of the hearing, including questions to guide the submissions of the parties and participants, as well as the order in which they are invited to address the Appeals Chamber. That is a summary of the background to the proceedings of today. Turning now to the conduct of these proceedings, it is recalled that in the decision on the conduct of hearing, the Appeals Chamber indicated both the order and the time allocated to the parties and participants to address the Appeals Chamber. The proceedings will thus be conducted in accordance with that schedule. Before we begin with hearing from Council, I would like to direct the parties and participants on a few modalities with respect to the hearing. In addressing the issues, the participants should be guided by the questions set out in the decision on the conduct of the hearing. They are free to speak to these questions in the manner that is most convenient to them. May I also remind Council that they are expected to complete their submissions within the indicated time frame. The court officer will be monitoring the time and will indicate to the party or participant 5 minutes before the end of the time that the time is about to end. The time allocated is based on 3 court sessions with time for questions from the bench, which may come at any time. Without further ado, I now recite the questions that the parties have been given to keep in mind. 1. In what circumstances may the Appeals Chamber reconsider its judgment taken pursuant to Rule 158 of the Rules of Procedure and Evidence? B. If the Appeals Chamber may reconsider its judgments taken pursuant to Rule 158, what is the applicable standard? Beyond the question of reconsideration, are there any other reasons for the Appeals Chamber to review and revoke the conditions of release set out in its decision of the 1st of February 2019? D. Does the relief sought by the prosecutor in her appeal brief in the main appeal against the acquittal of Mr. Gbagbo and Mr. Blé Goudé, namely a declaration of a mistrial, have any bearing on the necessity of the continued imposition of the conditions of release set out in the judgment? Those are, in brief, the questions the parties are to turn their minds to in addressing us. Now, I would invite submissions from Council. Council for Mr. Gbagbo will go first, and you have 30 minutes.
Mr. Altit. Thank you, Mr. President. Mr. President, Your Honors, Professor Jacobs will address the Chamber on these issues. Professor Jacobs.
Monsieur le Président,
Mr. President, Your Honors, in response to your first question concerning the circumstances in which an appeals chamber may reconsider a judgment taken on the basis of Rule 158 of the Rules of Procedure and Evidence, the defense's position is as follows. First of all, the issue of reconsideration as such. We looked at reconsideration and review, and we thought that reconsideration was necessary. And why did we come to this decision? Because reconsideration relates to the rationale for the decision for which we are asking a fresh review. In this case, the decision of 1 February 2019. Whereas review has to do with modalities of the decision, not the rationale for a decision. Now, it is the rationale for the restrictions placed upon the freedom of Laurent Gbagbo. That is what we discussed in our application of 7 October 2019. Indeed.
Do you have authority for that definition of distinction between reconsideration and review? Is there a legal authority that you can refer to us that should guide that understanding?
Mr. Jacobs. Thank you, Mr. President. It appears to us that it's the very logic of the two operations that lead one to make this distinction, insofar as review allows to ask a chamber to look at changes in circumstances, whereas a reconsideration allows us to ask a chamber to review the very substance, the very grounds for a decision, for example, to avoid an injustice on the basis of erroneous reasoning or a lack of factual foundation.
La défense estime
The defense is thus of the view that, in principle, no restrictions can be placed on the freedom of a person who has been acquitted. This person should be able to enjoy all his rights, including his civil and political rights. This principle is recognized by all international courts and tribunals that safeguard human rights. For example, the European Court of Human Rights, in the Labita decision of the year 2000, was of the view, and I quote from paragraph 171 of that decision, detention for the purposes of Article 5.1c ceases to be justified on the day on which the charge is determined. And that, consequently, detention after acquittal is no longer covered by that provision. End of quote. In this regard, the defense notes that the Hassanidze ruling from the European Court of Human Rights was much the same, contrary to what the legal representative of victims would have us believe, as she set out in her response of 16 October 2019 to the defense application of 7 October 2019. In actual fact, the legal representative of victims stated that the existence of a judicial decision was sufficient for restriction of the freedom of an acquitted person, and she was of the view that was lawful. I refer you to paragraph 37 of filing 1278, a filing from the legal representative of victims.
The authority you cited from the European Court of Human Rights was saying that detention is no longer valid upon acquittal. But Mr. Gbagbo is not in detention. Is there a difference?
Professor Jacobs.
Monsieur le Président, nous
Mr. President, we are of the view that
okay, I was told that I had not activated my microphone. Thank you, colleague. My question was this, that the detention, the authority you cited from the European Court of Human Rights was focused on detention of an acquitted person. But my question is that Mr. Gbagbo is not in detention. So does that authority apply? Does it guide our discussion now?
Professor Jacobs.
Merci, Monsieur le Président.
Thank you, Mr. President.
Nous estimons que
We are of the view that
la jurisprudence de
the
la CEDH
jurisprudence
peut être
of the
appliquée à toute mesure restrictive de
ECHR
liberté
can apply to any restriction upon the liberty of a person who has been acquitted. And the principle is clear. An acquitted person is immediately released
en l'absence de toute raison, par exemple, liée à
unless
d'autres
there
affaires
are
en cours ou c'est-
any reasons relating to other cases underway. But essentially, once a person has been acquitted, there is no legal foundation to place restrictions on this person's freedom.
C'est notre compréhension de la jurisprudence.
This is our understanding of the jurisprudence, Mr. President.
Does that scenario take its bearing from the essential circumstance that in a national jurisdiction, when an accused person is acquitted in a national jurisdiction, and there is an appeal against that acquittal, if that appeal succeeds, it's just a matter of the police attending and rearresting that person for purposes of any further trial. So in a national jurisdiction, that would not pose a serious problem as such. But on the ICC, there is that disability that the court does not have the facility of going and having somebody rearrested so easily. It is a need to continue a trial. Does that scenario make a difference? If not, why not?
Professor Jacobs.
Merci, Monsieur le Président.
Thank you,
Deux
Mr.
choses.
President. Well, there are two things at
La
hand.
première
First of all,
est qu'il, nous considérons que
we are of the
respect des droits
view that
fondamentaux
respect for fundamental rights
est un principe absolu
is an absolute principle,
et qui ne doit pas
and
s'accommoder de
the
raisons
principle
pragmatiques.
should not be infringed upon for pragmatic reasons. International criminal justice is supposed to be an example in this area, and thus a pragmatic matter having to do differences between domestic courts and this court. We are of the view that that is not relevant
L'application
because that only
du respect des droits fondamentaux.
fundamentally, this is about the respect of fundamental rights. Secondly, in relation to your remarks just now, I will come to that point in a few moments, but there is a difference here. In these proceedings, the prosecutor is asking for a mistrial.
C'est-à-dire que même
In other
si son
words,
appel
even if her appeal is successful,
That's a different consideration. If you want to base an argument on that, there is a separate argument
Yes.
segment. But you just said that the distinction doesn't matter, you say. Simply you said it doesn't matter. And the premise of that argument is because you say the respect for human rights is an absolute principle. Is it an absolute principle? Does the European Convention on Human Rights and does the International Covenant on Civil and Political Rights say that human rights are fundamental? Absolutely so. There is never a scenario where some exceptions may be made. Is that what you're saying?
Professor Jacobs,
Alors, qu'il existe des possibilités
that possibilities exist in human rights treaties, possibilities for exceptions to certain rights. We were not going to enter into that area. Some rights do not allow.
We want to see the limits to which some of these liberties could be modulated, offset by other considerations others may think are also valid considerations. And you're saying we're not going to go there, but that is exactly where we are.
Monsieur le Président, pour répondre
Professor
de manière simple à votre
Jacobs,
question,
to
la
answer
réponse est
simply, the answer is
il
no.
n'y a pas de considération
There are
pragmatique
no pragmatic considerations that would justify an exception to a human right, namely the right to freedom, which is recognized as a right that allows for no exception. So pragmatic considerations do not justify any sort of exemption or waiver from such a fundamental human right. With your leave, I would remind you that the Supreme Court of Kosovo.
Now, because I do not know whether there has been misinterpretation, I did not say pragmatic considerations. I said other considerations.
Merci, Monsieur le Président.
Mr. Jacobs, yes, thank you. It was me who used the word pragmatic because you raised what I thought was a pragmatic matter, namely the recovery or the finding of a person in relation to an versus an absolute principle. As I was saying, the Supreme Court of Kosovo itself, in relation to the special chambers for Kosovo, International Hybrid Tribunal, said on the 17th, refused to adopt an identical provision to the same statute from the Rome Statute, saying that that provision was contrary to the Constitution of Kosovo, and secondly, to international human rights jurisprudence. So it was an international tribunal that was of the view that even in the circumstances you set out, it is not possible to restrict the freedom of an acquitted person.
Professor Jacobs, is there any difference in principle between an acquitted person who is gone through a judicial or legal proceedings and a person who is accused of an offence but is nevertheless to be regarded as innocent under the presumption of innocence?
Professor Jacobs. As you know, on an ongoing basis, we have asked for the release of Mr. Gbagbo throughout the course of the trial to respect the principle of presumption of innocence and his right to freedom, a very principle that we upheld even during the trial. That is our starting point. This right continues even during a trial. We have now come to a later stage in the proceedings.
Dealing with it as a matter of principle, Professor, the reality is that in many cases where somebody is awaiting trial and is presumed innocent until that trial has been completed according to due process, there are restrictions often placed upon a person's liberty. For instance, they may be required to surrender their passport to the police or to regularly attend at a police station in order that they should not flee the jurisdiction. That's commonplace as conditions of bail pending a trial. and yet that person is to be regarded as innocent under the presumption of innocence.
Professor Jacobs. Thank you, Your Honor. Indeed, those circumstances do exist. And I think it's important to realize that those measures can be imposed only if there is an identifiable material risk demonstrated that the rule, well, even during the trial, if it is displaced. And once again, acquittal changes the situation radically. To our mind, the situation is radically different, and this is what we find in human rights jurisdiction, which tells us that once a person has been acquitted, there is no legal grounds for imposing restrictions upon freedom. That is not the case during the actual trial.
Is public order a ground for modulation of human rights?
Professor Jacobs, yes, the Convention does allow for a number of exceptions for the protection of the public order, but once again, those exceptions must be demonstrated. And the risks must be demonstrated. They must be true risks based on objective and identifiable risks. It can't be some vague risk of a threat to the public order. There has to be a concrete material risk that would impose the restriction of freedom. It can't be a general waiver.
I doubt that many people will disagree with that proposition, that it cannot be based on vague modulation of human rights, subtraction of human rights cannot be based on vague suppositions. I think many would agree with you. So then it boils down ultimately to a matter of demonstration of the reason for the exception, isn't it? And if it boils down to that, what does it do to your original premise that human rights is an absolute principle, cannot be derogated from?
Professor Jacobs. Mr. President, the fact that there may be derogations to certain rights, that does not apply to all rights. And our position is clear. The right of an acquitted person to freedom cannot be derogated from, no matter what the circumstances.
You may proceed.
Merci, Monsieur le Président.
Mr. Jacobs. Thank you, Mr. President.
Donc, brièvement,
briefly,
I
will speak to reconsideration at the ICC and the ongoing jurisprudence, which says that reconsideration is possible if a clear error of reasoning has been shown, or in order to prevent an injustice. And, for example, I can quote the decision handed down by the presidency in the Katanga case, 38/26 of 25 June. A chamber can reconsider its own decisions under circumstances where the decision is manifestly ill-founded and the consequences are manifestly unsatisfactory. And I refer you to the Lubanga case, and this is decision 2705, 30th March 2011, paragraph 18. This jurisprudence was based directly on ad hoc jurisprudence from ad hoc tribunals and other instances. For example, the rules of procedure and evidence at the STL state that it is possible to have a reconsideration if, and I quote, if necessary to avoid injustice. So we can clearly see the main thread that runs through the jurisprudence. Reconsideration is allowed to prevent an injustice. In this case, an extended violation of the rights of a person who has been acquitted, and drastic restrictions on his freedom to come and go, his freedom of expression, his freedom to exercise his civic rights. I think it's also important to note that this violation of the rights is not frozen in time. This violation becomes worse and worse as time goes on, because temporary violations of the rights of the acquitted person become the long-lasting removal of the person's rights. The acquitted person is stripped of his rights, stripped of his most essential rights as time goes on, his rights as a citizen and his rights as a man. Another element to take into consideration is the procedural context. Indeed, the prosecution's appeal has considerably extended the period of time during which Laurent Gbagbo has been deprived of his rights. This extension of time is such that reconsideration is now required. That is to say, the situation must be considered in light of this new development. The prosecution's notice of appeal of 16 September 2019 are...
The reason I needed to intervene, I want to separate two things. You move from one thing to the other now. So first, let's consider the first matter. You're now talking about the extended period in which you say necessitates reconsideration. So that's a separate proposition. But dealing with your original premise as to clear error, that's what I want to get at now. Say the jurisprudence authorizes reconsideration where the original decision was based on clear error. That's what I wanted to address us now. And the argument to make in that regard as to clear error. Are these new arguments? Were they not made in the original debate on whether or not to grant the conditional release? The argument that to grant conditional release would be limitation of freedom, and that should not be. That was argued before, wasn't it the case? If that was argued before and the appeals chamber nevertheless proceeded, can we say that there is a clear error that warrants reconsideration, or are you just re-arguing against the judgment of the appeals chamber afresh?
Professor Jacobs. Thank you, Mr. President. Indeed, we have expressed that principle in our earlier hearings in 2019. All the same, the issue of a clear error in reasoning was rather part of the reasoning of your appeals chamber in your decision. And until we can review that decision, we cannot know in which way you will argue that issue, the legal foundation that you will adopt. For example, on the 7th of October 2019, we made an application and we could have explained why we believe that the Articles of the Rome Statute, or the rules found in the Rules of Procedure and Evidence that you quoted in your decision, did not allow one to justify the restriction on the freedom of an acquitted person. We are not aware of the grounds that you based yourselves on. So we are in a position to raise specific issues that emerge from your decision relating to errors in reasoning or matters of law, and that is the case because, by definition, the parties present arguments before the chamber before any decision. And if that were to prohibit any kind of reconsideration, then there would never be any reconsideration.
Professor Jacobs, I have to be slightly cautious. You've quoted the jurisprudence of the Special Tribunal for Lebanon, the Rules of Evidence and Procedure, and the reason I have to be slightly cautious is that I assisted in the drafting of that when I was a judge in that court many years back, and I'm trying to recall the parameters of the expression "to avoid injustice." What you're saying is that something which might not have been so readily apparent as an actionable injustice at a point in time, nevertheless might grow and mature into an active injustice as a result of what happens or what doesn't happen through the passage of time. Is that a basic but fair understanding? Yeah.
Professor Jacobs, Your Honor, yes, that is our position. Once, if we begin with the initial injustice, namely the restriction on the freedom of the person, with time, the violation or this violation of freedom becomes worse and is more founded. This is an argument, in addition to other arguments, allows one to justify reconsideration.
Je poursuis.
I shall continue. Just to save some time, I'll move on to the standard, namely our response to your second question. I think we've partially responded already because in the circumstances where reconsideration is possible, each circumstance includes its own standard, in a manner of speaking. So, if it is a matter of preventing an injustice, the applicable standard depends on the demonstration of the injustice. If it is a matter of demonstrating an error in reasoning to show that a decision is ill-founded, the jurisprudence requires the errors to be shown manifestly. I won't hark back to the details of our 7th of October application, but we believe that in that application we demonstrated that, as I just said, from a legal point of view, there was manifestly a lack of grounds, and I would add from a factual point of view, we were of the view that the appeals chamber in its December of the 1st of February 2019 only referred back to earlier decisions taken by the trial chamber and made mention of the risk of flight without any true material information that could underpin that allegation. So there was no factual foundation. Above all, we stress that your chamber, in the decision of 1st of February 2019, decided to trust the judges of the trial chamber by referring back to their earlier decisions in 2018. And so you relied upon the decisions they took to keep Mr. Gbagbo in detention. But then, when the time came to trust the trial chamber, when that trial chamber decided that there would be an immediate unconditional release, there was no trust. So you see the discrepancy here.
Donc pour nous, les erreurs
To our mind, the legal and factual errors that we have identified
sont manifestes
are manifest and lead to an injustice.
et l'injustice
And the
semble
injustice
pouvoir être l'angle qu'il convient d'adopter ici pour discuter l'atteinte drastique aux
is
droits
such
fondamentaux
that
du personnel.
we are in a position to speak of a violation of a person's fundamental rights.
J'en viens maintenant à votre question C.
Now I will move on to question
Même si la Chambre
3.
d'appel devait considérer
Question C. Even if the appeals chamber were to decide that its decision was well-founded and principled,
il n'en demeure pas moins
all the
que nous
same,
estimons qu'un
we are of the
réexamen
view that
doit
a
être
review
procédé à un réexamen.
must be conducted.
Donc réexamen au sens de review. D'ailleurs,
A review.
réexamen tel que vous l'avez
A review, as you yourself provided for in paragraph 4 of the disposition of your decision of the 1st of February
concernant le cadre applicable à ce réexamen,
2019. As for the framework,
par analogie avec les procédures
by
de
analogy
réexamen
with
de la
proceedings to review the detention during the course of the trial,
détention, où la charge de la preuve
or
repose sur l'accusation,
during which the burden of proof lies with the prosecution, and as Judge Morrison has stated, there is the presumption of innocence. It follows logically that the lifting of conditions,
et éventuellement la
and
Chambre
possibly the appeals chamber, if the appeals chamber decides to maintain the conditions, the violation of the rights are justified today
d'appel, dans le contexte
in the current context.
Alors, brièvement, trois
Briefly, 3
raisons pour
reasons
lesquelles il devrait y avoir
why
un réexamen.
a review is necessary.
Premièrement,
First of
nous
all,
l'avons dit tout à l'heure,
as we said
tout à l'heure,
earlier,
l'appel formé par le procureur
the prosecutor's appeal
Counsel, you have 5 minutes left.
Merci.
Professor Jacobs, thank you.
Donc, premièrement,
First of all,
nous le disions tout
as
à l'heure,
we said
l'appel
earlier,
pouvoir
the
constitue
prosecutor's
un
appeal is a new development,
puisque
a
l'appel,
new fact,
avec l'appel,
because with this
les atteintes
appeal,
aux droits de Gbagbo s'accentuent.
the violations of Mr. Gbagbo's rights are growing worse and worse as time goes on.
Deuxièmement,
Secondly,
il convient que la Chambre d'appel explique
the
concrètement
appeals chamber needs to explain exactly on what factual basis you rely upon to place these restrictions on the freedom of Mr. Gbagbo today. And as we have said earlier, it is not enough to refer to older rulings that date back 3 years.
pour nous, en
To our
l'absence
mind,
de tout élément
unless there is a updated, relevant item of information brought before the chamber, since the prosecution, in their response of the 18th of October 2019, provided no concrete or new information justifying a restriction of freedom,
la seule issue logique
the only logical outcome
d'abandonner
is
toutes les
to
conditions restrictives de liberté.
lift all conditions placed upon Mr. Gbagbo's freedom.
Troisièmement, un
Third,
mot sur ce que signifie
one
le cadre
word
pour l'examen.
about
Le choix que fait le procureur
the prosecutor's decision to ask your chamber to make a declaration of a mistrial.
et donc j'en viens à votre dernière
And this leads me to your last question, Your Honors.
Would it be fair then to say perhaps that it's a question? The facility of review, rather than reconsideration on grounds of clear error, the facility of review might be the better way of dealing with a scenario where an original decision that may have seemed right at the time, but over time events, the passage of time may have shown to perhaps be inapposite. That's one way to deal with a matter, through the facility of review. Would that be your one way to look at this?
Professor Jacobs, absolutely, Mr. President. We are of the view that if you take it from the perspective of a review, it is quite possible for your chamber to review the conditions that were placed earlier. It is a legal remedy available to your chamber. Yes, indeed. Thus, regarding the mistrial, in our view, this application from the prosecution changes things considerably, because currently, with the current state of play, there are two possibilities. Either your chamber does not grant the prosecutor's application and the trial comes to an end, and Laurent Gbagbo's fundamental human rights will have been violated for nothing. Or your chamber grants the prosecutor's request for a mistrial and then the proceedings merely end, because at this stage the prosecution is not asking for a referral to the trial chamber or a new trial. And in that particular scenario, once again, Laurent Gbagbo's fundamental rights will have been violated for nothing. Furthermore, in the response from the prosecutor on the 17th of October 2019, they said that a declaration of a mistrial would change nothing, but that is hard to understand, because if the prosecutor herself is not, well, if she does not ask for the trial to continue after the mistrial, why would Mr. Gbagbo's rights be restricted? Why were they restricted during the trial? Correction, during the appeal. Thus, any question of an alleged flight risk is not applicable under these circumstances, because at the current stage of the proceedings, the trial shall come to an end. In other words, Laurent Gbagbo has nothing to flee from. To conclude, we are of the view that no matter what perspective you take, whether you opt for a review or a reconsideration, the circumstances are such that it is fitting to entirely lift the restrictions placed upon the freedom of Laurent Gbagbo's freedom, so that he may regain each and every one of his fundamental rights. Thank you, Mr. President.
Thank you very much, Counsel. We will now hear from Counsel from Mr. Blé Goudé. You have 30 minutes. We are in open session, just so you know.
Thank you, Mr. President. Mr. President, Your Honours, good morning. We'll address the first and second question together from a purely theoretical perspective, particularly in light of the fact that the court's statutory framework provides little to no guidance as to the circumstances for reconsideration of appellate decisions. Of course, needless to say that the framework does not exclude the inherent powers of the appeals chamber to reconsider its decisions to prevent an injustice, leaving apart now the question whether there was an injustice or not. We are answering these questions from a theoretical perspective for now, Mr. President. It's our view that principles of reconsideration of ICC trial chamber decisions could also apply to the appeals chamber. Practice before the ad hoc tribunals, where reconsideration of appeals chamber decisions is commonplace, may provide your chamber with additional guidance as to which test could be applied. Let us first see what The jurisprudence briefly dictates when it concerns the ICC itself, after which I will delve briefly into the jurisprudence of the ad hoc tribunals on reconsideration of appellate decisions. First, speaking about the ICC precedents, there is the decision of the 1st October 2019. That's our Exhibit 1 in our table of authorities, Prosecutor versus Nataganda, where the appeals chamber ruled on a request of the defense for reconsideration of one of its decisions, which related to the ordering of an extension of time and page limit. Although the appeals chamber did not, as itself admitted, take the opportunity to articulate the circumstances in which reconsideration might be ordered, it nonetheless granted the request in part. And interesting, Mr. President, the test which was applied and put forward by the defense was previously formulated by Trial Chamber number 4, the 23rd September 2019, according to which the Trial Chamber has the inherent power to reconsider previous decisions to prevent an injustice, paragraph 4. Again, I'm not going to the question yet whether this phenomenon occurs, whether in this situation there was an alleged injustice. We're just addressing the topic from a theoretical perspective for now. You see, therefore, Mr. President, the appeals chamber exercised in that case its inherent discretion to vary its previous decisions on an exceptional basis and took into account whether the defense had shown that reconsideration would prevent an injustice, paragraph 6 and 8 of its decision. Appeals chamber rejected the request in part, as mentioned, where it considered that the Nataganda defense merely attempted to re-argue points which were already made. What does this recent ICC appeals chamber decision in the case of Mr. Nataganda tell us, Mr. President, Your Honors? First, it's within the inherent discretion of the appeals chamber to reconsider its own decisions in accordance with Rule 158. That's our first submission. Second, it may do so to prevent injustice. 3, parties may not use reconsideration as a way to re-litigate points already made. And 4th, reconsideration might be ordered on an exceptional basis. So this is my first point, the standard derived from ICC case law. Now, let's briefly look into the appeals chamber decision and why it could apply the principles applied by trial chamber decisions to reconsider its own decisions, as it did in the Nataganda case. For instance, as a precedent in the Ruto and Sang case, that's authority number 3 on our list of authorities, the chamber held that reconsideration was not an alien concept at the court and had been occasionally granted, such as in the Kenyatta case, that's authority number 2 of our list of authorities. The trial chamber endorsed as justification for reconsideration where, I quote, it was necessary to better serve the cause of justice if the question of law is still with the chamber and there is merit to the urge for the adjustment. It seems to me, Mr. President, that this is more an extensive interpretation of the criterion to prevent an injustice. But as held by you, Mr. President, in that same case, the trial chamber, I quote from your own opinion, the opinion at the Ruto Sang decision, paragraph 87, quote, should be better should be neither shy nor afraid to take another look at the question of law that the Chamber had earlier passed upon, unquote. And therefore, it could adjust and refine a previous decision. Mr. President, you had further observed in that same opinion that, I quote, it's not beyond the realms of possibility that the Chamber did not get it fully right on the first occasion, unquote. And that suppositions of judicial infallibility are never borne out by the corrective facilities of reconsiderations, reviews, and appeals. Paragraph 136 of your opinion. Therefore, we submit, Mr. President, Your Honors, that these same principles could apply to appeals chamber decisions, and that it is precisely this reasoning which is implicit in the appeals chamber decision in Nataganda when it partially granted the defense request for reconsideration. Finally, Mr. President, touching upon the questions A and B, if the Chamber would delve into the standard applied by the ad hoc tribunals, you all might find further guidance. This ample case law, we have identified 6 precedents we will mention now in specific 3 of ICTY and ICTR appeals chamber decisions which have constantly relied on its inherent power to reconsider its own decisions in, indeed, exceptional circumstances. We mentioned 3. First, prosecution versus Stanislav Galic, our authority number 4 list, 16 July 2004, where the appeals chamber articulated a disjunctive test, either a clear error of reasoning in the decision or the particular circumstances justify reconsideration to avoid injustice. Now here I would take the liberty to answer the question of the bench addressed to Professor Jacobs, if you don't mind. First question was from Honorable Judge Warson, is there a difference between an acquittal on the one hand and a person who is charged but not yet tried and is presumed innocent? Yes, we believe there is a difference. A person who is acquitted, in that scenario, the charges are non-existent. The charges are non-existent. And therefore, the approach as to conditional release should be different. In the scenario where a defendant is charged but presumed innocent, he is still subjected to charges. And therefore, conditions to safeguard the investigation or a judicial process might be justified. But in the scenario where a defendant is acquitted, in most jurisdictions and also here, the charges are no longer existent. And that's why, in this scenario, the approach of this disjunctive test should be also put in the context of the acquittal, as opposed to a person charged but not yet tried. And secondly, the question whether the expiration of time could be a reason to say that the second prong of this disjunctive test has been met, namely to avoid injustice. The European Court of Justice, in many cases, like the first one in 1991, L'Atelier versus France, for the first time ruled that when time progresses, the grounds for conditional release or even provisional custody might attenuate. And therefore, for the European Court, that's a reason to sometimes say when a defendant is arrested because the public order has been infringed, when time passes over, that public order might perceive a certain crime different. And that might be a reason to lift provisional custody. Therefore, the expiration of time or the progression of time in itself might be an argument for reconsideration. This is just an observation from the bench of, from the bar of Mr. Blé Goudé, speaking about the case law of the ICTY.
Before you proceed, counsel, before you proceed, you tried, and we were very grateful for your assistance in trying to answer questions from the bench asked of other counsel. We welcome that very much. But in the process, you engaged question from the bench as to what is the distinction between a scenario where somebody who is standing trial and presumed innocent, what's the distinction between that and someone who has been acquitted and then given back full presumption of innocence, so to speak. Your answer to that, saying there is a sharp distinction, is it that clear? Is it that clear in the circumstances of this case? For two reasons. Ordinarily, after an acquittal, if the prosecution indicates or does launch an appeal against that acquittal, does it give us that neat distinction that the charge doesn't exist anymore, which is the basis of your answer, that there is a distinction, non-existence of the charges? Can we really say that so confidently when there is an appeal of the acquittal? That's one question, a general one, in a general scenario. But in the particular circumstances of this case, there's a further wrinkle, possibly. And that wrinkle being this: the case was stopped halfway at the close of the case for the prosecution, and in no case to answer submission was made. Trial chamber accepted the no case to answer submission. The prosecutor appealed that judgment, the natural effect of which would be, should the prosecutor's appeal succeed, the trial continues. Given those two scenarios, are we able to say with confidence that there's the distinction you drew really exists so clearly?
Thank you, Mr. President. In my submission, there is no distinction between an acquittal based on a no case to answer and an acquittal after the defense has presented its case. There is a clear determination of the evidence by a bench. The bench has determined that the charges are to be dismissed, are therefore legally non-existent.
But there's an appeal of that decision.
It doesn't take away that in the scenario of an acquittal, there is a determination of the charges being made, while in the scenario of a person still charged in an investigation but presumed innocent, the charges are still there. They are not yet determined by judicial authorities and not determined as non-existent or existent. In my submission, there is therefore no differentiation whether that the determination has been the result of a no case to answer or based on a full trial with the defense presentation, because ultimately the acquittal is based on the prosecution evidence and which is the core of the case, and therefore doctrinally there is a distinction between conditions pertaining to a person charged but not yet tried and conditions to a person who is already determined not guilty. Therefore, the charges, again, for the judge are dismissed and non-existent.
So effectively, you're saying that the system needs to recognize the basic distinction in a scenario where somebody has been acquitted versus where somebody is still standing trial. That's what you're saying. But is it possible to recognize that perhaps that distinction might have been accommodated? This is not a statement from me. I'm just asking you a question now. In the sense that in the particular circumstances of this case, when they were in trial, they were in detention fully, but after the judgment of the trial chamber, they have been released from detention but placed on conditional release. Isn't that recognizing the basic distinction between one stream versus the other?
Well, this is, of course, the interpretation made by the appeals chamber on the 1st of February 2019. But it's really the question whether, when in combination with the time which has progressed in this case, that could be an argument for reconsideration. And I was just alluding to a very interesting question of Honorable Judge Morrison, that in my submission, legally, there is a differentiation between the two concepts.
I mean, the real position is this, isn't it? The Crown, or the prosecution rather, I reverted to my own jurisdiction for a minute there. The prosecution has to have proved its case by the time it closes its case. There's no obligation on the defence to call evidence or any evidence, and it can simply rest at that point and proceed to submissions that the Crown, the prosecution, has not proved its case. That's a plain and obvious principle, and no doubt you would say that that underscores the distinction between the two positions as well. You add to that that apart, injustices can grow, and there would be nothing unusual in a court redetermining an issue after the effluxion of time if the argument was that there had been consequences that were not foreseeable or foreseen at the time that the original order was made. This is really thinking aloud, but it's commonplace, certainly in many jurisdictions, that where somebody has not been granted bail at all pending trial, that if the trial is for any reason adjourned beyond a reasonable time, the defence is empowered to go back to the court and use that as an argument for either altering the conditions of bail or having absolute bail. And that has happened on many occasions. And you would say that the principle that underlies that is in effect, without having to give absolute detail, a principle which is active in this case.
Yeah, Mr. President, I had, at the 1st of February 2019, your chamber could not foresee, of course, the length of the appeals proceedings. So the fact that we are now dealing with also the issue of time when the appeals proceedings could ultimately conclude might also be a reason, based on the case law of the European Court, for reconsideration, in combination with the distinction between the acquittal and the situation whereby a defendant is still charged. That's my argument. It reinforces the two elements together. Mr. President, in light of the time, I see I just have 7 minutes left.
Fair enough. We'll give you a few more minutes because of questions. There's one point you made. If you can help us with that, I'd appreciate it this much, very much. You did say that among the reasons for which reconsideration may be granted, or rather grounds, you said in exceptional circumstances that may also be done. That in exceptional circumstances, reconsideration may be done. Indeed. Can you help us what we mean by exceptional circumstances?
Well, exceptional circumstances is not an invention of myself, of course. It's the presentation of the case law to the chamber. It's for the chamber to determine whether exceptional circumstances exist. There's no definition. I didn't find any definition in the case law what is exceptional circumstances. It's really depending on the facts. It could, of course, include the, for instance, unforeseeable situation that a trial, even an appeal trial, takes longer than perhaps at the time the conditions for set were foreseen. That might be an exceptional circumstance. But I cannot give you a clear definition.
Fair enough.
Mr. President, to conclude the questions A and B, I mentioned 3 cases of the ICTY. I mentioned Galic. I will skip it because of the time for this precedent. I only mention 2 other examples we mentioned in exhibit in our table of authorities, authority 5 and 6, the Prilic case and the Stanisic and Soplian case, where you also find the same test applied by the chamber, appeals chamber, as compared with Galic. Now, we turn now to the question D, and I'll close with question C. Is there a reason, now the prosecution request for mistrial, is that a reason to reconsider the decision of the chamber of the 1st February 2019? Also here, Mr. President, we as defense team for Mr. Blé Goudé will address this topic purely from an international law perspective, purely from a theoretical perspective, without giving any normative conclusions. A mistrial would mean, and you will find in our appeal brief in due course a more extensive expose of what is a mistrial under certain jurisdiction, but a mistrial could have the effect of rendering the first trial against Mr. Charles Blé Goudé null and void. Therefore, it would imply that the proceedings are no longer to be considered necessary under Article 81(3)(c) sub 1 of the statute. That is, for us, the logical and legal sound result stemming from the observation that proceedings are no longer necessary and need to be safeguarded, assuming, of course, hypothetically, that a mistrial would occur in this case. Now, the conditions on Mr. Blé Goudé's were imposed after the appeal chamber found merit in the prosecution assertion that there was a risk of Mr. Blé Goudé to flee the country after acquittal and not appearing for the court, such that the proceedings against him might continue in the event the appeal chamber would reverse the decision. Conditions imposed by on Mr. Blé Goudé were found necessary by your chamber upon request of the OTP, therefore to safeguard the integrity of the proceedings. Given that in the present case the prosecution seeks for a mistrial and no retrial, leaving apart the legal basis for it, that's for the appeal itself, of course, Article 81(3)(c) sub 1, therefore the basis upon which your chamber rendered its judgment on the 1st of February no longer applies. And this might also constitute, I say, a reason for reconsideration. At the time your honors rendered the decision of the 1st of February 2019, you were not familiar with this relief the prosecution is seeking for. Now, the chamber is confronted with a totally different relief than expected. That might be, answering your question, an exceptional circumstance, Mr. President. This might be an example of an exceptional circumstance which was not foreseen by the appeals chamber, which was actually not expected, could not have been expected, and therefore might justify the conclusion this is an exceptional circumstance for reconsideration, that the reasons to apply Article 81(3)(c) sub 1 therefore is no longer applicable. In conclusion, from a purely doctrinal perspective, we submit that the announcement of the prosecution that does not wish to retry Mr. Blé Goudé implies therefore already the lifting of conditions pertaining to his release, simply because that Article 83 1c sub 1 no longer applies. Leaving apart, Mr. President, I stressed the question whether mistrial at this court under the circumstances of the acquittal of Mr. Blé Goudé can constitute a legal basis as a remedy in this case. That's something for the appeal, of course. But for now, the Chamber is confronted with a new circumstance which was not foreseeable on the 1st February 2019. Finally, Mr. President, question number C. The defense of Mr. Blé Goudé is in somewhat a dilemma. Let us suppose that the Chamber would anticipate this potential remedy. Let us suppose remedy the prosecution is seeking for. Let us suppose that you, Chamber, are willing to contemplate this potential remedy in the confines of this discussion today, preliminary discussion. Let us suppose that the Chamber, upon this anticipation, is considering the lifting of the conditions of the two accused, of the two acquitted, I have to say. Sorry. At this juncture, for Mr. Blé Goudé, it was still important that the court will impose measures which will safeguard his right to participate at the appeals proceedings without interference of the domestic authorities. And why are we seeking and asking for this measure? As the court knows from our exhibits, document 8, for instance, of the list of exhibits, the Court of First Instance in Abidjan convicted Mr. Blé Goudé on the 30th December 2019 in absentia for basically the same facts as he was prosecuted for before this court. He was convicted in absentia to 20 years imprisonment, 10 years entry ban in Côte d'Ivoire, 10 years limitation in participation of his civic life, and a fine of 200 million FCFA, based on a hearing which took less than 3.5 hours.
Counsel, as I said earlier, we are in public session, and you made reference to some filings you've made. Please keep that in mind.
I will not address the filings of the defense. I'll address just the
Fair enough. So
exhibits.
what I'm saying is just
Yeah,
keep
I
in
understand.
mind that we're in public session.
Thank you, Mr. President.
But
Yeah.
while at it, one thing you can help us clarify is whether now you are saying you're parting company with Gbagbo in the submission you're onto right now. In other words, you're saying that you're not in the same circumstance as Mr. Gbagbo. Is that what you're making us understand?
No.
Because when you say that, you still want some conditions to be imposed
No, Mr. President.
to ensure that Mr. Blé Goudé comes. Mr. Gbagbo is saying lift all conditions.
Yes.
And you're saying, what are you telling us? So we
Yes.
know who's where.
That's
Thank you.
Exactly. That's really a good question, and that's the dilemma. We are with the team of Mr. Gbagbo when we say from a legal perspective, and we have elaborated this extensively this morning. Legally, the conditions are to be lifted. But even when conditions are lifted, the court, in our view, has the responsibility that the acquitted person, i.e. Mr. Blé Goudé, is prevented from any external interference from his home country, which prevents him from participating at the appeals proceedings. And that's the reason why we submitted the exhibits, to show that he was subjected to a trial which was in contravention to international law.
Or maybe you can address us on that later, on what specific measures you are saying needs to be imposed if you are saying yes, all conditions should be lifted, so you're on the same page as Mr. Gbagbo, yet there are some measures you want put in place. So it requires some sort of fine argument to let us know exactly what it is.
Diplomatic pleading. Right. Yeah. Diplomatic pleading, I was saying, Mr.
Diplomatic pleading, you said, all right,
Yeah.
fair enough.
I can address that later, Mr. President. I can finish.
You can
my
return to
submission.
that later.
Yes. To finish, Mr. President, our submissions under question C, there are therefore also for the situation of Mr. Blé Goudé special circumstances which warrant the lifting of conditions, but at the same time, the court, when it would lift conditions, could in its disposition, in its ruling, stress the need that Mr. Blé Goudé is not at any moment subjected to interference from external proceedings, which interfere also with Article 20, Section 2 of the statute. You will see in our exhibits that this proceeding in absentia, where he was convicted in 1 hour 20 after the requisitoire of the prosecutor there, convicted, that this trial, this conviction, actually went into the same facts, the same materials as being part of the case file here. On top of this, there is evidence also shown at the trial in first instance. There's also prosecution witness that Mr. Blé Goudé was subjected, before he arrived here, subjected to an inhuman treatment by the authorities. All this is to say that if the court is to lift conditions because of the standard we suggested, because of the presence of exceptional circumstances, i.e. the potential mistrial and the other arguments, that we still seek the court to render a ruling that Mr. Blé Goudé is not to be interfered by the authorities. And, Mr. President, therefore, it is of paramount importance that this court will stress the need that his presence in The Hague is secured. That declaration itself, although we are not in an Article 20, Section 2 proceeding, in itself will be very important. We can announce, Mr. President, that this defense team will proceed for an Article 20, Section 2 application in due course, because the evidence before this chamber, produced also by the prosecution, and we submitted this yesterday in our table of authorities, and the court can look in the documents 8 till 12. Also, the arrest warrant against Mr. Blé Goudé, issued on this conviction in absentia, relates to the same facts as being put by the prosecution before this court. And the Ivorian government, in March 2014, transferred Mr. Blé Goudé for trial here. You cannot eat the cake from two sides, Mr. President. And therefore, in light of also this arrest warrant, which is issued against him, that's document 12 on our exhibit list, we, at the closing of our submissions, we seek therefore from the chamber a declaration that even if the conditions are to be lifted, that the national authorities are not to interfere with Mr. Blé Goudé's right to participate at this appeal. Thank you.
Do we understand your submission to ensure that if he needs to be in The Hague for his hearing, that needs to
Yes, Mr. President. That's the point we would like to make. Thank you.
All right, we'll leave it at that from you. Prosecution, I think it's your turn now.
Thank you, Your Honor. I understand that you wanted to take a break in about 10 minutes, so I wonder whether it would be a good time to break now, and that perhaps we start 10 minutes earlier, or do you want us to proceed?
You can proceed until we get to the time.
Okay, very well. In any event, before I do proceed, I would like to raise a housekeeping point, and could we go into closed session for a moment, please?
We'll go to closed session. We will do private session.
Very well.
Yeah.
Thank you.
Members of the audience, the blinds will be drawn for now, so we can have some housekeeping discussion.
We are back in open session, Mr. President.
Let's see what we can do in 5 minutes. Proceed.
I'll give an overview of our position in 5 minutes. Can I proceed? So before I address you on each of the 4 questions that you posed, I'll sum up our position with the following 2 points. First, irrespective of whether and under what condition the procedure of reconsideration of judgments under Rule 158 is permissible, there is no need to resort to such a remedy in this case. This is because other procedures are available to review the Appeals Chamber's judgment of 1 February 2019. And second, there is no need to review and revoke the conditions of release set out in your judgment last year for any other reasons. This is because since the 1st of February 2019, nothing has changed. I will elaborate after the break that there has been no change of circumstances for either Mr. Gbagbo or Mr. Blé Goudé. Nothing has happened which would affect the Appeals Chamber's conclusion that their release on conditions is necessary, that they do not abscond, and to prevent the appearance before the court. In addition, there has been no change in the prosecutor's position with respect to the remedy that we seek in our appeal. The prosecutor intends to continue proceedings against Mr. Gbagbo and Mr. Blé Goudé. This means that if her appeal succeeds, the prosecutor intends to retry Mr. Gbagbo and Mr. Blé Goudé. And my counsel will elaborate on that point later on. So perhaps now we can take the break, because I will then start elaborating in detail on each of the...
Fair enough. I think you've been asking for that break. We might sort of take it. This is the time for it now. The court will rise for the morning break for reassemble in 30 minutes.
Thank you very much.
All rise, vous vous levez.
This is all very messy, the way they're conducting